Dear students, welcome back to Property Law, HOE 6011. So we'll be looking at sales today, and I spoke a bit about it last time, just in an introductory sense, and I hope to cover more grounds today, of course. And this is, well, a very general topic of property law, very conservative, the usual stuff. Nothing really has changed over here much. So we'll be looking at some of these issues. And well, homework 3 has been put up as well. So I hope you pay attention to that part. Homework 1 is already due, and I'll be checking those assignments soon and grading them in Moodle. So homework 2 is, yeah, I think in the next week or so. And then homework 3 is already 25th April. So you have more than a month for that. Remember, there are 5 homework assignments in this particular course this time. And a few more things. Well, just, as a matter of precaution, just wanted to let you know that the property law course is being radically changed for the new term. And so it's advisable to get it sorted out and done this year, because next year it may be a bit different from what you're used to. All right, because they're combining some other elements, and it becomes a 6 credit course in 2022. Whatever, but until then it's still the same course right now. uh, Try to finish it off this year. Okay, so sale of immovable property, and the notes are of course in Moodle as well. So we'll be looking at some elements of sales and how they work out, and the various definitions. Of course, we'll be looking at a mix of English law, then French law, and then of course a lot of it is quite similar to what you also have under Estonian laws, for example. But there are some very important changes or differences, so you have to be careful about this. Now, those of you who attend the lectures of Thomas Hoffman, you probably must have figured out by now that Germans do things a bit differently compared to how would you say, common law countries, English speaking countries. And well, it's not so different for many of you, because if you're from Estonia or Finland, then or Sweden, the Germanic viewpoint is quite prevalent. But in other countries, that's not entirely the case. The UK and the US, etc. So we'll just look at some of these elements. Of course, it's a 3 credit course and very simplistic. Sorry, the comparisons are not really something to go into in detail, but just some things I'll try to point them out so that you can be aware about these issues. Now, when you look at a sale, well, of course, we're looking at sales of immovable property. Yeah, so it's not a pen or a car or a laptop. We're talking about houses, or flats and things like that, land as such. So a sale is defined as a transfer of ownership in exchange for a price paid or promised, or part paid and part promised. Now, this is just one of the many definitions you find across the world. So it is, it's interesting because there is a transfer of ownership, which is why it is a sale. And of course, there has to be a price element over here. How it is paid, how it is done, is a bit of an issue. Another very important element to consider is delivery. And delivery of immovable property takes place when the seller places the buyer or such person as he directs in possession of the property. Now, this would be classic English law, but of course, delivery could mean different things in other legal systems. And you have to be very careful over here, because in some countries or in some legal systems, your sale is complete on delivery, whereas in other countries it may just be that sale and delivery are two different concepts. So again, this is of course hair splitting. Well, if you're doing a thesis on something like this, then it can be a very wide topic, because there's a lot of scope for comparisons here. And this is the reason why very often it's not possible to have a European Union directive or regulation that covers many topics of law because there are just too many national differences. And sorry, one example of this would be, for example, commerce, of course, is regulated. Jurisdiction is, there are regulations for that. Family law with some attempts, yeah, but criminal law, for example, it's very difficult to draw common ground between different member states. And the same even goes for sales or delivery, concepts like that. Now there's a contract for sale, and of course, this is a contract that a sale of such property shall take place on terms settled between the parties. But that's it. It doesn't really go beyond that. Again, it's very specific to some countries. So, for example, you could have an agreement of sale, yeah, a contract of sale which says that I will sell my house to you for 1 million euros. Yeah, and then you say, yeah, you agree to buy the house from me for 1 million euros. So that's it. Two parties, they have entered into an agreement. It's an agreement of sale, and they have identified the property, immovable property. They have identified what the price should be, and they have identified all other factors, rights, liabilities, indemnities, the usual clauses in an agreement. But that's just it. That's an agreement of sale by itself. It doesn't really do anything as far as that property is concerned, because that property is only given to you or delivered when you have a separate deed of conveyance, and it specifically mentions that you grant, release, convey, assure, assign, transfer the property. Now, again, this is very traditional English law way of looking at things, or common law, US, UK, New Zealand, Australia, India, these sort of places. So that's why it might be very different from what you see in continental Europe, for example. So again, you see there are these differences here, and as lawyers, it's just that you may be an Estonian or a Finnish lawyer, but you may have to do a transaction in London. So then you have to be very careful about these differences and how they play a role. So in such a scenario, you have an agreement of sale, and the agreement by itself doesn't bind the property, but rather the people who are signing the agreement. You see, there's a subtle difference over here, which means then if the seller refuses or the buyer refuses or backs out, then on the basis of this agreement of sale, either you could ask for damages, yeah, because Pawan had a really nice house, it's worth 1 million. Now Pawan says no. Now the next house on the market is Pawan's neighbor's, same location, but maybe it's 1.2 million. So what the hell, who pays extra 2.2 million? So of course, this could be a ground for litigation. On the other hand, you could have a suit for specific performance. Again, very common under English law, but I don't know how it works out in other countries. And it could be that, no, I want this house, only this house, because this house is the key, and without this house, my dream is not possible, and whatever. Again, what we are disputing over here is not the property, but rather there was an agreement, and now one party wants to back out from the agreement, and so a contract for sale, I hope you can now understand, doesn't really bind the property in this context, but more or less it binds the people. Of course, you could have a combination of both. Yeah, the agreement of sale and the conveyance could be in the same document. Yeah, you could do that also. So there are a lot of variations and a lot of possibilities, and so again, as lawyers, you have to be careful about this. Now, I've put up Title 6 of the French Civil Code, for example, over here, and it outlines, in the different articles, how delivery takes place, how a sale is completed, what are the, conditions, precedent or subsequent. And so really, property transactions in a legal sense need to be done specifically by a lawyer who understands that local jurisdiction and the rules and requirements. My advice to you is, if you are a Finnish lawyer, don't just land up in Bulgaria or in Algeria and say, I'm going to buy a property, and how difficult or different can the transaction be. They can be very different. Like for example, I know in some Arab countries, especially in northern Africa, yeah, Algeria, Tunisia, Morocco, really beautiful places. Yeah, okay, not Libya so much, Egypt. Yeah, so of course, you could have amazing properties and a lot of very wealthy people, designers and fashionistas, and everybody have houses and gardens in Tunisia and Morocco and everywhere. So of course, property transactions do take place, but then in such countries, very often you can buy the house, but the land belongs to the government. You know, that's a bit strange, but that's how it is in some countries. Then in some countries, what you're buying may actually not be freehold property. It may be something that belongs to the government, and the government gives it out on lease for 100 years or 400 years. Now again, this is a very weird situation. Now what that means is, you're buying an interest in the property, so although you could call it a sale, it's not really a sale in that sense, and it really all gets mixed up because of course, if you're buying something which gives you rights for 100 years, is that a sale, is that not a sale? Well, these are again, of course, very important questions. And so again, what I'm trying to impress over here is that property law transactions need to be really thought out very well. So let's go away from this and look more at rights and liabilities of seller and buyer. Now, these sort of transactions take place. I know it's a bit weird. It's a sort of a rite of passage in a way. Yeah. You don't really become an adult in some social circumstances or communities unless you actually own properties or have a house or a flat or something else in real estate terms. And then of course, this can give you a lot of protection, safety net in a way. It's a good investment very often. Like for example, right now property prices are going up, for strange reasons. I was seeing example in Finland, sales of single family large houses, detached houses, with a single house and a garden around it, and a big house. These sales are up 20%. Renting, that's also up in a way. Property prices are going up even though the pandemic is causing this, this environment, this economical semi crisis in a way. It could be for different reasons. Property prices are going up maybe because there's this risk of inflation, and you have €1 million sitting in the bank. What can you get for it? Nothing. So interest rates are negative in a way. But you could actually buy property and then maybe rent it out and things. So there's a lot of demand for these sort of issues. So not everybody rents property. Very often people prefer to buy, and then also, you could inherit something from your family or whatever, and now you want to sell it. So sales, as such, buying and selling of property, immovable property, is a very popular aspect of commercial life, and a lot of people do that for different reasons. Maybe they're upsizing, maybe they're downsizing. So I'm sure most of you have had some sort of experience in this regard, or have been thinking about these issues. So, well, of course, now we have to look at certain legal aspects. And, well, I don't know if you're aware, but there is this one concept known as caveat emptor. And what that means is buyer beware. Yeah, you buy it, it's sold as is, where is basis. It's very common, for example, when you want to buy a car. Now, of course, we're dealing with immovable property here in this particular lecture. But just to give you an idea about a car, there's a Mercedes car for sale, 5,000 euros. Yeah, well, it's buyer beware, caveat emptor. The car is there in front of you. Open it up, check it inside out. Do whatever. Once you shake hands, you buy the car. That's it, the end. After that, you can't come back and say what the hell, the parts came out or whatever. And that's how they say that there's nothing more expensive than a cheap Mercedes. Yeah, because you have a lot of problems with spare parts and all sorts of things. And you take out one part, second part gets knocked out, third part needs replacement, the fourth part, the fifth part. So of course, that's caveat emptor. You can't go and say, what the hell, you sold me a lemon. It's there. You have eyes. If you don't know what you're buying, then what the hell, why do you want to buy stuff that you don't understand? But that doesn't apply necessarily in the case of a sale of immovable property. Again, this is very important as a lawyer to be aware of. And well, when you or a client wants to buy property, immovable property, of course they will conduct a due diligence. The due diligence would be in different forms. You would look up the property register to find out who is the owner. There may be a situation where there are multiple owners, there's a legal dispute, something like that. Then you will also physically inspect the property. That's very important. Now, one added measure or layer of protection could be, you buy the property using a bank loan, in which case the bank's lawyers will now also check the property in detail and try to look at every aspect of the property. And a lot of interesting things can come out in that sense. For example, in Estonia and in Tallinn, it could be quite a problem in some situations where the house is in a panel house, from the Soviet times, and then it was designed to be a two-bedroom house, a flat with a living room and a kitchen and a bathroom and a balcony. And then, I don't know, somebody in 1986 or 1990 made some changes, put the kitchen there, put the bedroom there, and then, internally changed the whole layout. And Soviet times, post-Soviet times, anything happened there. Now, what happens if you want to sell this property, this flat? Suddenly it's an issue. It may not be an issue if you're buying it with cash or direct cash transfer, money transfer, but if you are buying it by taking a bank loan, then the bank people will come and check the house and the flat, and they'll say, hey, all of these flats are the standard variations, standard sizes, and there's two-bedroom hall, kitchen, living room, whatever. So how come this has three bedrooms? Obviously, there's been an alteration. Is this a legal alteration? Has this been notified? And for that, it's a different ball game. You have to get permission from the architect, from the government. You have to do all this planning. You can't just take a panel and move it here and there. That can be very dangerous, and it could result in instability in the complete structure of the house. So very often then you cannot sell this house or this flat because it has been altered. And then if you want to sell this flat, you actually have to put it back in the original condition, but you can't do those sort of things by just shifting a wall from here to there, because now you need to have permission from 90% of the other flat owners in that house or whatever. So a lot of interesting things come out. Another similar situation was in the news about 10-15 years ago. Now, near the airport in Tallinn, there's a Petri Kula, and so in the late 90s, early 2000s, the developer built some houses. There were a lot of construction activities there. And now, again, even more and more. I went there a few months ago and I was shocked. This place has really changed. But it's interesting to see what are the problems. What happened was the developer, the original builder who had developed and built some of these houses 20 years ago, only had permission to build certain types of houses. Maybe what do you call them, row houses, in a line, or maybe something like that. But what this guy did was, he just built 3-floor houses. He built some detached houses. He built something else, and whatever, and even got the paperwork done by the council, the county people. So everything is done. It's on paper. That would be Raiwald. Yeah, they gave a certificate. Everything is fine. And people have been living in those houses and flats for 20 years, no problem. And then once somebody wanted to sell the flat, and so they got in touch with the prospective buyer. And these people, the buyers, didn't have the money up front, so they went to take a loan from the bank. And the bank lawyers came, they did all the due diligence, and they said, what the hell, according to the original plan, this should have been a single family detached house, but actually you have, four row houses there. But they said, yeah, what's the problem? We have the certificate from the Rai Wald, yeah, from the county people. So what's wrong? I said, no, that's not actually true. And then the house owner went to the government office to say, what the hell, 20 years ago, what did you do? And they said, yeah, well, shit happens, whatever. Sorry, we can't change it. We can't do anything. It's not our problem. It's your problem. And this is crazy, right? Because you have maybe a house that's worth 400, 500,000 euros, but the paperwork is not correct, and now the government department is saying, well, it's not our problem. The original construction company is not around, so it's not their problem. The architect, has died or whatever. It's not his problem. So whose problem is it? Well, nobody knows. But they say, well, you can stay in your house. What's your problem? Well, yeah, my problem is I can't sell the house, right? So of course, these are important aspects, and that's why due diligence is very important. Has to be done properly. So a lot of Finnish students I know have bought flats in Rotormani and other places near Virukeskus. So there's a lot of interest. A lot of people do these sort of transactions for Airbnb purposes, renting, whatever. So liabilities of the seller is bound to disclose to the buyer any material defect which the buyer could not with ordinary care discover. Yeah, you see that? So that's a very important aspect over here. It's not caveat emptor. You have to reveal if there are any material defects either in the property or the title. Yeah. So again, if there's a crack in the wall, you don't just cover it with a giant window or a mirror or a painting or something, or some curtains. You're supposed to explain that, oh yeah, the roof leaks, or there was a giant mushroom growing in the ceiling, or whatever. So you cannot just hide these facts, especially when you have some type of houses or flats which are not properly heated. So then they can have these fungal infections, and then that can be quite problematic for people with asthma or other diseases. Then of course also maybe the water pipes have a problem. They are old, or all sorts of these things have to be revealed. But then of course, to produce to the buyer on his request for examination all documents of title. Okay, yeah, that's clear. Documents of title nowadays, with everything being digitized on the property register, which is online, so that's much easier to answer to the best of information all relevant questions. Yeah. Then of course, if the payment is made, to execute a proper conveyance. Remember, I told you agreement, and then there is the conveyance part, which could be combined in some situations. Between the date of the contract of sale and the delivery, this could be quite different in different situations. Like for example, I bought a flat a couple of years ago in Tallinn, and so how does the process go? Well, you go to a notary, and I transfer the money to the notary, and then the buyer, that's me, and the seller gives the documents and the flat keys to the notary, and then on a certain date everything is signed, and the notary transfers the money to the seller, and the house keys, the possession, to the buyer. Simple, straightforward. And of course, this is that means that I could transfer the money today, and the meeting is tomorrow at the notary's place. I could change my mind, before signing the final document. So you have a lot of these issues that you have to be careful about. Very often, we agree that yes, I will buy the house for 1 million. So the notary meeting is tomorrow. We go to the notary's office, and then I say, no, I changed my mind. I will give you 750,000. Can I do that? Yeah. Why not? Because this agreement has not really been signed. Because it's property law, you cannot have oral agreements. Agreements have to be in writing, because that's how the law goes. So you see, there's a lot of these things that come into play over here. So of course, you could have a contract of sale and delivery, and in between that period, who takes care of the property and all the documents. So again, these are issues that come up, because in my case, it was a distress sale. So the seller had a problem with the bank, so he could not immediately transfer possession. He had to find me, and I agreed to buy the flat. And now he had to go to the bank and say that, look, I have a loan. I mean, he has a loan, and he has to pay back the loan. And now he has found a buyer for the flat, and now the bank needs to release the mortgage terms and things so that he can transfer the flat to me and then take the money and then pay the bank. You see, so there are a lot of these complications that can often arise. To give possession when required, to pay all public charges up to what date. So sometimes you could have a situation where I agree to buy, you agree to sell, but you say that we do the deal today, but you get possession only in August, because of certain things. So of course, you could adjust the price, you could negotiate certain things, but yeah, these sort of things are relevant over here. And of course, then also when you are deemed, so when does the interest subsist, and of course what happens with all the documents and titles. Now, what is relevant, is sometimes a bit weird. Okay, now again, these are issues. There are some examples over here: a house built on a landfill, a snake house. You have a problem in the house. The problem is that there are lots of snakes in the house. Yeah, well, I know it sounds funny, but if you see the example here, it's not funny, because apparently there's a nest, and then you have hundreds of little snakes and things. So of course that can be quite a problem. But maybe another issue could be, oh, okay, well, Capital Gazette is not available in the European Union. Good thing I checked that out. House built on a landfill. These are all American sites. That's there. Okay, so let me make a note. Snake house link needs to be changed. Yeah. Um, okay. Now maybe another example would be, again, from a personal viewpoint. This was a long time ago, and my parents were looking to buy a flat, and this was in a different country, and so they were very interested in a particular flat, and they really liked it, and everything was going on track, and seemed to be a good price, and really ticked all the boxes. And so they were quite happy and almost ready to complete the deal, so it would have been done next week, for example. And then they met some family friend, and they said, hey, don't you live nearby? Actually, we even saw this nice flat over here. It looked like a nice neighborhood, and um, maybe soon we'll be neighbors again, or whatever. And so that other person said, hey, but which flat is it? Is it that flat? And they were like, yeah. And they said, oh, don't you know, the previous owner's wife committed suicide by hanging herself from the kitchen ceiling or something. Yeah. Now, of course, would that make a difference? Well, my mother got very spooked out about it, and she said there's no way that she's going to live in a flat where somebody has committed suicide, and that's a very violent sort of a way to die, and then she'd be scared of a ghost or something. Now, of course, different people are affected in different ways. The point I'm trying to make here is, would this be a material defect? Yeah, is this something that you should tell the prospective buyer or seller? In this case, the buyer. So again, legally, these can be quite interesting issues that can arise, and they can have quite a lot of ramifications. Basically, you're trying to walk out of €1 million deal because you're scared of ghosts. Is that a valid reason? Yeah. So again, you see, a lot of these issues do arise, and as lawyers now, it's our duty to bang our head and try to find out what the hell is the way out of this situation. So of course, these are some of the very simplistic liabilities. I try to give some examples, and I hope you sort of saw through what I'm talking about here. Then there's the rights of the seller. Just as you have liabilities, you have also rights. Liabilities are duties, yeah, and then rights. So the seller is entitled to the rent and profit of the property till the ownership thereof passes to the buyer. Yeah. So again, very important. Maybe, I have a flat and I'm renting it out on Airbnb to different people, and so now we have a sale. So who gets to keep the the Airbnb rent or whatever? And then, of course, where the property ownership has passed, but before the payment of the whole of the purchase money, to a charge upon the property in the hands of the buyer. So it could be like, it's a €1 million flat, and I agree to sell it to you. You agree to buy it from me, and we're all fine. And we say, okay, how are the payment terms? So you are the buyer, and you say you will pay €750,000 upfront, and 250,000 after the bank loan gets approved, which will get approved. It's just that it takes a bit of time, paperwork. Maybe it's Estonian National Day, or coronavirus time, and some delays are happening. But payment goes through. It's just that the notary is whatever. So of course, what happens in that point of time? Well, you have sold, but that buyer still owes you a part of the payment, €250,000. So again, there have to be a lot of flexibilities, because nobody walks around with €1 million in cash. You always in the pocket. You always have some of these issues that come up. So what are the liabilities of the buyer? Well, the buyer is bound to disclose to the seller any fact as to the nature or extent of the seller's interest in the property of which the buyer is aware, but of which he has reason to believe that the seller is not aware, and which materially increases the value of such interest. Now, simple example would be, let's say, you have a house, grandfather's cottage in Vanta, and it was built during 100 years ago or something. So of course, it's always been there. Now Vanta has this airport outside Helsinki, and a lot of plans. Of course, with pandemic now, not so many plans, but maybe there's something going on. So let's say I work for the Ministry of Aviation or something, and I find out that next month Vanta Airport extension plans are going to come into effect, and they're going to be debated. And this is top secret right now, but next month it becomes public knowledge. And so there's a plan that the Finnish government will help the Vanta airport authorities to expand the highway, and make it more suitable for long distance flights from Asia or whatever. And this is a part of the government of Finland's plan to make Helsinki and Vanta an international airport hub like Frankfurt or London or whatever. But this is secret knowledge, not out yet. So I work in the ministry and I come to know about this, and now, well, you have your grandfather's cottage, and apparently it's going to be in the way. So I go to you and tell you tomorrow, hey, I was passing by and I saw this quaint little broken wooden cottage that you have. I saw that it belongs to you. Do you want to keep it? It's so crazy, isn't it? I mean, so close to the airport and stuff. I'll give you €25,000. Would you sell it to me? And then you're like, yeah, nobody lives there anyway. Okay, take it. But what the seller, you don't know, and what I, the buyer, know, is the secret knowledge that next month, when the government of Finland issues the notification that yes, this plan is going to be taken up more seriously, the property prices all around there will go up, because the Finnish government is not going to just take away houses from people. They will pay you a certain market value, and of course, when people come to know about this development, then the market value goes up in some situations. So I had insider information, which of course you didn't. So the liability of the buyer is to disclose this. Yeah, so you see, this is very important here, because a lot of things happen in this context. People have insider information, people know certain things. It's like, I'm in prison. My friend in the prison who's with me tells me that he had buried gold in or diamonds or something, which he had stolen from a bank, in the garden of your aunt. And so now this guy dies in prison, and so I know the secret. Now I go out of prison, go to your aunt and say, hey, hello, old lady, let me buy your stupid, idiotic, broken down garden cottage for €50,000. Yeah, because I like to help old women like you. And I just throw the money and I buy it. But what she doesn't know is I'm going to be digging up the garden because I know I have the secret information that there is a hidden stash of stolen property there. You see, all of these are important aspects, liabilities to be aware of. Another liability is to pay or tender the purchase money to the settler. Yeah. And where the ownership of the property has passed to the buyer to bear any loss arising from the destruction. Yeah. So of course, the liability of the buyer is, let's say there's a house and X buys the house today, and then tomorrow the house catches fire and burns down. Tomorrow. Yeah, so X bought it today, and tomorrow this horrible accident happens. Who's responsible? Yeah, the buyer, right? You can't go to the seller and say, "What the hell? I want my money back." Of course not. You got the house; it's yours. You're the owner now. It's your problem. And also, of course, there are also issues as to who pays the public charges, rent. Very often, these taxes are payable after a year. So let's say I sell the house in March, yeah, and then the new tax has to be paid in on 1st January. So the question is, I have now lived in the house for 3 months, and you, the buyer, are living in the house now for 9 months. So we have to divide, accordingly. Simple stuff, but of course, very important to keep in mind. Then the rights of the buyer, very often you see what are the liabilities of the seller become the rights of the buyer, and vice versa. So it's easy in that sense to remember. And of course, where the ownership of the property has passed, then the buyer is entitled to any improvement in or increase in value. Yeah. So the property prices go up, yeah, then the buyer, he's the owner now. Of course, if he knows about this secretly, like I gave the previous example, then there's an issue. But otherwise, you buy a house and then tomorrow the property prices go up. Good for you. And then of course also, if you have paid as a buyer, then you have certain interest and you can charge, impose a charge on the property. So again, simple concepts. Then there is marshalling, and that's a very interesting issue. Basically, let's say the owner of two or more properties, yeah, property A and property B, mortgages both of them to a bank, yeah, and gets some money. And we'll talk about mortgage next time. And then sells property A to you. Now, of course, so this guy has two houses, each are worth €1 million and 2 million, and now has a bank loan of 1 million. And now he sells the property to you for 1 million, and there's still 1 million left. So, who is responsible for payment? Well, in this situation, as a new owner, you could say that the bank should make the previous guy, the original owner, to satisfy the debt out of the property that he has not yet sold, that which is still in his possession. So that's marshalling. You can read more about it here. It's an interesting take on things. Of course, in some countries, this is all contractual. Like in Estonia, for example, a lot of things are just simply contractual. So the state assumes that you have brains and that you don't need protection. In many other countries, it's not always that straightforward. The state imposes a lot of restrictions. So let's stop here for today. Sales done. Yeah, make sure you complete your homeworks on time. I'll put up some new links over here, and then we meet again next week. All right. So until then, thank you and goodbye.